Thank you and good afternoon. I want to focus on the future of high-tech and antitrust enforcement in Europe by asking what the European Commission should have learned from its long ordeal with Google, which you know is, of course, not yet finished. Now, I'm sure you know generally what happened here. As Google became dominant in general search, a group of companies emerged called CSEs, comparison shopping engines, and their goal was to enable users to find the best deal on products that they were interested in buying. These companies worked very well. They showed users the lowest prices. Users used them. As a consequence of all that, they were ranked very highly in Google's general search results. Google entered the market with its own CSE. It then, thereafter, began to artificially demote, reduce in search rank the rivals, and enhance its own offerings that I'll explain in a second. But before I get there, I think the first question that we need to confront is, why did Google do this? Because that's the key to understanding the future of antitrust enforcement. I think that Google must surely have known at the time they started this conduct back in 2007, that they would one day be sanctioned by the EU because the conduct pretty much looks illegal under EU law. So they knew with absolute certainty, I think, yet they did it anyway. Why did they do it anyway? I think there are two reasons. One is that these companies posed a significant strategic threat to Google. This is not well understood here or at the European Commission, I don't think. And the second is, I think Google made a calculation because they knew how things operate here, and they concluded that even after paying a fine, they'd come out way ahead by 10 years of anti-competitive conduct. So I think that's what happened. So why did Google go after the comparison shopping rivals? Well, not to make a bunch of money in comparison shopping. I think it's because the comparison shopping sites threaten Google's core monopoly profits in general search. You see, the rivals intended to do very well in comparison shopping, get more and more users signed up. Then they were going to launch travel sites. Then they were going to launch local search sites. And they would combine all those offerings much the same way that Google does to have a combined offering in commercial search. They were going to challenge Google in all of commercial search, and that's where Google's money comes from. You see, Google makes its money selling ads against queries for products and hotels and travel, that kind of thing. Not so much ads against queries for esoteric literature searches. So these companies were aimed at Google's heart. And they had already, by 2007, set up their own search syndication. They had set up their own ad syndication. They promised greater control for publishers, something Google could not possibly tolerate. I know all this because I represented a number of these companies from the beginning. I made these arguments to antitrust enforcement officials, and it wasn't just me. In 2006 and 2007, the computer press in the United States was filled with articles about how Google was losing out in commercial search to these new CSEs, and Google was being threatened by them. And in internal Google email presented to the United States Federal Trade Commission, clearly those emails indicate that Google felt this risk and knew it had to do something. So, what did Google do? The first thing it did is canceled its comparison shopping engine. It was called Frugal at the time. It wasn't very good. And then Google went dark for a year to make a plan. And then starting in the United States in 2007 and rolling out into Europe in 2008, Google came out with its new and improved comparison shopping site called GPS, Google Product Search. You see the actual beta screen in front of you from the US. These screenshots I'm showing you are not mock-ups. They're actuals of what happened. The problem for Google was that creating a better service wasn't enough. You see, the rivals were even better. They had better features. They had more users. They had more merchants signed up. So Google started a campaign of illegal conduct, first in the United States and then rolled it out into Europe. Because this first started in the United States, the best place to go to understand what Google was thinking and trying to do is the US documents. These were produced to the United States Federal Trade Commission. They prepared an internal confidential study portions of which, by mistake, they sent to the press. The FTC did. So the Wall Street Journal published this in 2015, and this is the best source I know for how all this started. This is the Wall Street Journal site. Now, I think a lot of people get a headache trying to look at this because only every other page is published. But the real information, frankly, is in the footnotes. And the information I'm going to give you now is particularly in footnote 154 and 168, if you want to ever check on that. So they show from Google's own email what Google actually did. So the first thing that Google did is they made a list of companies to target. Here are the rivals we want to target, and our goal is to take them down 20% in their traffic by search manipulation. Now, there was a problem Google had because in order to change its algorithm, it had to go through its own internal testers. And so it brought this proposal to the testers, and testers said, the rivals are better. They deserve to be at the top. So Google went back and massaged the algorithm, came back to the testers. Testers said, no, even under the algorithm, the rivals are better. They deserve to be at the top. And by my count, and this happened a third time and a fourth time. And finally, Google management got exasperated and told the testers, don't make side-by-side comparisons anymore of who's better. Think of it a wholly different way. And only then were they able to get what they said were slightly positive feedback results that enabled them to go forward with their plan. Okay, so what did Google do? Well, as I say, you know generally, and here's a screen from the UK from the time that shows you what Google did. They put their own results. I don't mean they put a link to Google Product Search at the top. I meant they put the shopping results from Google Product Search at the top, together with images of products and what's called dynamic pricing, so you could see exactly what was available in merchant inventory. The rivals could all support that. The rivals asked to be able to do the same thing. Google would not cooperate. Instead, Google demoted the rivals, and you see the top rival listed at the bottom of the page there. This is an actual screen. Google's internal documents show that after the implementation of this plan, Google personnel reported to their superiors that they had achieved their goal of taking down the rivals 20% in traffic. At more or less the same time, Google came out with a new kind of ad, and this is the secret to Google's great profitability. No longer just text ads, but what are called product listing ads. The ads had the same kind of images and dynamic pricing. Google sold these ads to merchants, even to Amazon, but they wouldn't sell it to the rival CSEs, even though they had promised not to discriminate. Now, Google's actions in 2007, 2008, demoting rivals and preferencing its own results badly damaged these CSEs in both the United States and Europe, but it created a big problem for Google that you see on the screen in front of you. You see Google's own shopping service, GPS, continued to show the lowest price in merchant inventory for whatever product the user was looking for. And merchants were included free in that service, so they had the incentive to price as low as possible so they could get the very top listing. This is great for consumers. It was terrible for Google. Why is that? Because Google was trying to sell ads to these same merchants, and they were charging the merchants for the ads, and so the merchants had to increase their listed prices in order to cover the amount they were paying for Google. Created many situations like this where you see a particular model of a Canon camera listed more cheaply in the free results than in the ads. Well, of course, users aren't going to click on the ads, so merchants aren't going to buy the ads, so Google has a big problem. So what did Google do about it? 2011 in the United States announced, and then implemented 2012, 2013 in Europe, Google killed its own comparison shopping service, GPS. It eliminated it entirely. It didn't just rename it, as the Commission has said, it killed it. And they came up with a new service called Google Shopping. Google Shopping was just ads, what you see in front of you, just the PLAs. Google also demoted rivals even more severely, as the Commission has said. And between lowering rivals to the fourth or fifth page of results and killing its own service that let users see the lowest price, users increasingly lost the ability to find the lowest price available in merchant inventory for a particular product, because all they could get from Google were ads, and merchants had to pay more and more for these ads. The changes in 2007, 2008, these first set of changes really hurt rivals. But the subsequent changes in 2011 and 2012 really hurt consumers. Now, back in 2013, when there were still some rival CSEs that were viable, I did a confidential study that I sent to DG Comp, to the Commission, comparing product prices that the demoted rivals were listing as compared to ad prices for the same products at the top of Google Shopping. And the study showed that Google was overcharging consumers by as much as 80% for the very same products. My study was confidential, but a well-known consumer group in the United States, Consumer Watchdog, did a very similar study and got very similar results. Even the FT, the Financial Times of London, did a study, which they put on the front page, about how Google was concealing the lowest available prices. Consumers couldn't find these prices because the rivals were now on page 4 and page 5 of the search results. So many of the companies went out of business. Those few that survived were badly damaged. What did the US government do about this? Nothing. They actually closed their investigation of Google without even studying the 2011 and 2012 changes. And they had the gall to tell the press that they really couldn't understand how consumers were hurt by what Google did, but of course they didn't study the part of the equation in which consumers were damaged. Now, we always thought in the United States it was going to be difficult to get anything out of the Obama administration on Google because of all the campaign money and influence that Google had directly with the President of the United States. But even we were shocked when it came out afterward that the White House had assigned a staffer to monitor this case in the Federal Trade Commission, and according to these press reports, he called the various commissioners to ask them how they would vote, and then he reported that to Google and encouraged Google to go forward. That's what the US did. What did the EU do? Well, I don't really have time today to tell you all the things that Commissioner Vestager's predecessor, Joaquin Almunia, did, or more correctly, didn't do. He engaged in years of fruitless negotiations with Google, Google all the while continuing its anti-competitive activity as company after company went out of business in Europe. I will tell you quite cynically, sometimes I think that Mr. Almunia put more Europeans out of work than Mr. Trump ever could, but there you have it. I don't mean by my criticism to include the professional staff. The professional staff at this time worked very hard to keep this going, and they're the reason we have the prospect of a remedy here today. Mr. Almunia was eventually replaced by Commissioner Vestager, but it took her a couple years to get going. And so we didn't have a decision on the penalty until this past June. This is 2017. This conduct started in 2007. 10 years of unremedied antitrust, anti-competitive conduct in the technology markets. As you heard earlier today, a generation of product in the technology markets is 2 years. This is 5 generations of product that the bureaucracy let go by without any antitrust remedy. Okay, what was decided? We don't have the official decision yet. Confidentiality is still being negotiated, but we know from what's being said in the summaries that there were some things that were decided. First, as was noted in the introduction, Google is a dominant company in general search, and as a dominant company under EU law, has special obligations to protect competition, and specifically in this situation must offer equal treatment to its rivals. This is not a new standard for the Google case. It's been employed many times by the European Commission. It was also decided that Google has infringed EU law in comparison shopping by preferencing itself and demoting rivals. And now what's supposed to be done about it? What's the remedy? Well, Google's supposed to provide a remedy. Now, I know that sounds a little strange. I call it the you broke it, you fix it approach, but frankly, it's the right approach. And I've been making speeches for years in Europe that they ought to continue to do that. That's what they did in the Microsoft case to great effect. So I think that's the correct approach. Those are at least some of the things that were decided. What I don't think was decided turns out to be a lot more important. So first, what's the purpose of the remedy? I don't mean mechanically to put, the rivals at the top of the search results. I mean, what are we trying to do? Are we trying to restore competition so that after the remedy, we have the market we would have had, but for Google's anti-competitive conduct? That would be very good. Or are we just saying to Google, pay your fine for the past and don't discriminate in the future? What we call in the antitrust field the sin no more approach. For years, commentators in Europe have said that the sin no more approach is not appropriate, that the antitrust remedy needs to restore competition. You can understand why. If Google ends up ahead from its anti-competitive conduct, no company would ever be deterred. But from what Commissioner Vestager has said, I think the Commission is focusing on the sin no more approach. Just don't discriminate in the future and pay your fine for what you've done in the past. Also, not clear is how the remaining CSEs will get placement. I mean, these companies have been badly damaged. And Google rightfully say they're just not very good anymore. They don't deserve the top rankings. Of course, if Google did that, we'd have no remedy at all, so that doesn't make any sense. Commissioner Vestager has said that the injured CSEs can go into their national court and file lawsuits and get a damage award. And she said that would be easy. I think that's her word, easy. I've been litigating for decades. I don't think litigation is ever easy. But I think all this misses the point. I mean, you heard from an entrepreneur earlier. Many of you are entrepreneurs. In my experience with U.S. entrepreneurs, no one would go through these kinds of 10 years of toil and frustration with the prospect of some court remedy. You know, entrepreneurs do this kind of thing because they want to get wealthy, because they want to bring new products to market, because they want to change the world, not because they're looking for some court damage award. And so if that's what you're offering in Europe, I think you're going to tune out a lot of entrepreneurs. And finally, there's the issue of the application of this to these other specialty search categories like local search for hotels and restaurants and travel search. It doesn't look to me like coverage is automatic. I mean, if these companies have to, in these other sectors, have to wait now 2 or 3 years for a decision in their area, they'll be out of business as well. So when Commissioner Vestager announced the result back in June, she had a press conference and she was asked by a member of the press, what did you learn from all these years of investigating Google? And I think this took her by surprise, and she kind of stumbled through an answer, and she said, I learned that each case is different. Well, I don't even know what that means. That's all she learned. All of you were in desperate trouble. So I've taken it upon myself to make some suggestions about what I think the Commission ought to have learned, and doubtless some of you have suggestions as well. So first, you need to pay attention to who gets appointed competition commissioner. You have an excellent competition commissioner now, previously not so much. And the reason I raise this is as an outsider, I don't understand how the competition commissioner gets appointed. See, it's totally opaque to me. It seems like it's some kind of backroom deal. And here's my concern. In the United States, Google has acquired so much money and so much influence that they can influence political appointments, including the ones that regulate them. And I'm very much afraid that the next time you have a competition commissioner appointed, Google's going to have a seat at the table in that back room and you won't even know about it. Because the process isn't visible to you, and you won't have a seat at the table, and that's not going to lead to good results. I think you need better merger controls here in high tech, as we do in the United States. You have great merger controls in some of the other sectors, but these companies have acquired a lot of their power by buying smaller companies that would have offered competition. There's no reason, for example, that Google should have been able to buy Waze. It already had Google Maps. Maps are crucial in our new web economy. So a lot of these deals should be investigated with an eye toward prospective competition of the acquired companies and banned or prohibited. But that hasn't been happening in the high-tech area. I realize it's difficult for the Commission. Many of them are U.S. deals. Nevertheless, that's where the action is. Speed matters in these network markets in terms of an antitrust remedy. In other words, if we don't fix it on the merger, we're going to have to remedy it later on. That's where we are in the Google case. Once competition is gone in these markets, it's gone. It doesn't come back. Now, I'm sure there are some stronger German CSEs that might benefit from the remedy in terms of the fact that they'll get stronger, and that's great. But none of the CSEs are going to be able to do what they wanted to do from that first slide I showed you. They're never going to be able to challenge Google in all of commercial search. We all had that opportunity. We wonder why Google is dominant today. We had the opportunity in 2007 to prevent it from happening. We squandered that opportunity. Don't let it happen again. How do you avoid doing that? The Commission needs to be able to go into court and get what's called interim relief. It needs to be able to stop anti-competitive conduct before it has completed a whole investigation. We have that in the United States. We call it a preliminary injunction or a temporary restraining order. Commissioner Vestager has said, I can't do that here because the courts employ too strict a standard. They require the commission to show irreparable injury. Well, I've just told you about the irreparable injury. This competition isn't coming back, not the way they want it to be. So they could have gone into court, I think, and gotten interim relief. But if the standard is too strict, challenge it and fix it. You can't just accept it and have 10 years of unfulfilled antitrust enforcement before you can do anything. That's not a good way. In one of the prior discussions, there was a discussion of startups around here. And it's been my experience over many years, and I've been coming back and forth since Mario Monti was the competition commissioner. The European Commission is more interested in hearing from big companies than they are from startups. And of course, we all know, in the United States we know, and increasingly all of you know, that much of the change and progress and great technology comes from startup companies. They can't even get appointments with your commissioners. So that's got to change. Until you learn to protect nascent competition, you're never going to achieve the goals you've been talking about here. And finally, we all need to think strategically. We can't just have a case against Google in one market and then a remedy against Google in another market and even a third market. We need some greater plan. Now, I think that kind of strategic thinking may be going on in the Digital Agenda Directorate and perhaps in DG Comp as well, but there doesn't seem to be any indication that these individual cases that you're seeing tie into some plan for making the market more competitive. I think that needs to happen. Certainly, you can't wait for the United States. I mean, because of changes in our situation, we may never break up a monopoly ever again. So you're on your own. You need to act quickly. Good luck.
Thank you, Gary. In order to take this discussion a step further, we've invited our dear friend Andrew Keen. Andrew is an internet critic. He has been called the conscience of the internet, and he has written books like How to Fix the Future and The Internet is Not the Answer. So let's fix this case. There you go.
Thank you. That was an amazing presentation, Gary. Very balanced, of course. What did Google ever do to hurt you? Have they been watching you, Gary? Is this how you always behave, or is it just the legal?
I've been restrained here a bit because I know that Berta wants it. Well, in the United States, Google has programs like this where they don't disclose their sponsorship. I'm never invited to them. And here you have a Berta presentation, and I get invited, and the Google speaker right after me to rebut what I've said. That's not the way it works elsewhere. And maybe there'll come a time it won't work that way here, but that's the way it works now.
So let's try and connect the first part of the morning's conversation with what you just presented. Are you adding, Clark Parsons, in an excellent presentation, gave 5 conditions for a European renaissance. I don't know if it's really a renaissance. It's a beginning for their digital industries. Are you saying there's a 6th, that Europe, if Europe is really to be competitive in digital, it needs the kind of coherent, aggressive, anti-monopoly strategy that you pointed at, not only for Google, but perhaps also for Amazon and maybe Facebook?
Well, I thought Clark's presentation was quite excellent. I thought what I have to say fit right into his first category. I mean, he started with antitrust enforcement. And, there have been questions here today about what specifically can be done. So I tried to talk about specifically under his first category some things that could be done. I do think that an integrated approach is a better approach, will get you better results here, would get us better results in the United States. But some approach is better than no approach.
But let me try and nail you, just as you tried to nail Google here. Are companies like Google, Amazon, Facebook, these maybe even Microsoft, these dominant West Coast American companies, these dominant platforms, are they in their own way an active barrier against innovation, particularly in Europe, which hasn't acted in a protectionist manner? As I think Clark mentioned, you know, China could get going because it had protections at first. But if Europe is to genuinely develop its own indigenous digital industries, are you saying that it can come through regulation, or might it need protection?
Well, some very good questions there. First, let me say that I've studied at Google and worked in the Google cases for quite a long time. These other companies represent different situations. So I'm going to try to confine my comments as best I can to the Google situation where I actually think I know something, whether I do or not. First, on your last point on protectionism, I hope you don't go down that road. I mean, after today's presentation on protectionism, I remembered the presentations I'd heard from my own dear president on protectionism, recall that he thinks there are too many German cars on our highways, that there are too many German pharmaceuticals, German chemicals. I mean, do you really want a trade war that might cut you off from a very large market? I think your new generation of entrepreneurs can compete on a level playing field. I think you'll do well. I think we'll do well too. But I think that's what you should be aiming for and not some protectionist approach. Likening yourself to China, my goodness, you're all open democracies. These are data companies. Are you going to cut off your own people from data? I don't think that model will work very well for you. So I would advocate antitrust enforcement, which is not quite the same, Andrew, as regulation. Regulation, there's a body of people selected in some way who try to manage the company that they didn't come out of. And they tell the company how to set price and who to sell to and so forth. In our experience in the United States, that doesn't work very well. An antitrust approach is that the government sets the rules of conduct, the rules of the road, if you will, and then it steps back, lets the companies fight it out as long as they obey those rules.
We had John Frank from Microsoft. Gary, you were 20, 30 years ago, your legal venom was directed at Microsoft rather than Google. You were instrumental in the Microsoft case in the US. Is history essentially repeating itself now with Google and Microsoft? Is Google the new Microsoft?
Yes, I think I've made many presentations, ineffectively, I suppose, to our antitrust enforcers in the United States, explaining that everything that Google is doing has been done before by Microsoft. As I explain it, there are only 5 or 6 or 7 plays in the monopolist playbook, and you just execute them on a new playing field each time. So this conduct isn't really very different. What you try to do if you're a monopolist is to cut off access to market of the next generation of technology. That's what you do. That's what our first great monopolist, John D. Rockefeller, did. Cut off access to the other oil suppliers so they couldn't get to market. That's what Google is doing here by manipulating its search results. You can't find these CSEs anymore easily. You need to be able to do that. So yes, I think it's a very similar situation.
Speaking of playbooks, most of you are familiar with the playbooks, at least for monopolies. Most of you are familiar with the Barry Lynn story that broke last week in the US. Barry Lynn is an antitrust expert, one of your, I guess, a comrade in arms, who worked for the New America Foundation, which was backed partially by Google. He came out with a report that commended Vestager's decision, which resulted, I think, in Schmidt putting pressure on New America to fire Lynn. Created a bit of a scandal last week in the U.S. and a nice vacation from Trump scandals. Gary, did this shock you, as in Casablanca? Was this something that really surprised you, or is it what we need to expect from Google in terms of its playbook, in terms of protecting itself as a monopoly?
Yeah, there are certain areas in which this situation is different from the Microsoft situation. And one of those is that Google has spent astronomical amounts of money funding liberal think tanks in Washington, D.C., making campaign contributions, sponsoring programs, and so forth. They've now started doing this in Europe. The people I know in the European Parliament say you can't imagine over the last year how many different people now on Google's payroll visiting the European Parliament on Google's behalf. I think in some ways you might be a little naive if you're not focusing on this. There is more money at stake. I mean, Google is playing with monopoly profits. As we like to say in the United States, they have more money than God. So you're going to have to take account of how they can use that money to influence governmental decisions, and I'm not sure you're thinking about that.
A couple of questions from the audience, especially any liberal think tankers out there who are supported by Google. We will have a guy from Google after Gary to balance things out.
I think there's one over there to your right.
A Google think tanker or just a
I don't
question?
know. He can identify himself.
Identify yourself. So very brief, please, because I'd like to take a couple of questions.
I'm Stefan Winders from Border. I have a simple question. America has a great tradition of great prosecutor. If you have all this information, Gary, you spoke out, also the fact that Mr. Schmidt had direct access to the President of America. I mean, when is a prosecutor in America stepping up and really digging himself through that?
The prosecutors in the federal government in America report to the President of the United States. So unless someone is appointed and empowered to do that by our president in our Justice Department or in the Federal Trade Commission, it's not going to happen. I mean, we're now in a period of uncertainty because we don't really know who President Trump will appoint to the Federal Trade Commission. We don't really know a lot about the person he has appointed, someone not yet confirmed, to the Antitrust Division. But they can't operate without they're not like independent prosecutors. They're not like the independent prosecutor now investigating President Trump. They can't operate without the executive branch empowering them to do that, and we don't have such empowerment yet.
Other questions? This lady in front.
Google creates an ecosystem for entrepreneurs, so they have the first, if there are new startups, they'll be the first people to know. So that's the advantage that Google has, and that's why they can foresee who's going to be competing with them in several spaces. So how do you deal with that? Microsoft didn't have that problem.
Correct.
But Google has. Google has what you call Google for Entrepreneurs, and it has all the tools that different startups for different purposes, all the tools that it needs to build a startup.
Yeah, so I only have a couple of seconds to reply to this. Microsoft actually tried to do that, but Google has been much more effective. We need to change our rules in the United States so that we get information about these smaller acquisitions. Right now, they don't have to be reported to our government. And you can't stop Google from collecting information, I suppose, but you can stop them or at least investigate these smaller acquisitions, because you're right. The entrepreneurs, if they're successful, they just get bought before they can be a challenge.
One more question, anyone? Brief? Sure is. Anyone want to attack Gary, tell him he's wrong? Maybe our next speaker. Thank you, Gary, that was great.